right, ladies and gentlemen, we're going to get into some very important discussions here today on personal jurisdiction and court appearances. With me is Kirk from Kirk's Law Corner, and we have recently teamed up to collaborate in any way possible to help take down the corruption and tyranny that exists in our judicial system, at the very least to empower Americans to be able to go into the lion's den and come out alive, if at all possible, if I can put it that way. So, Kirk, welcome. Today we're going to talk about jurisdiction. So let's just jump right into it. You've got a very special approach that has proven successful on various occasions. So tell us about it.
All right, so just a brief background. I discovered this through a family law case when my attorney had left the case, and next time I appeared, the judge says, "Hey, I need a notice of appearance from you," and they have one down there at the court assistant's office. So I checked the rules on it, and it's called a notice of special appearance or general appearance. Voluntary appearing automatically admits jurisdiction. Now, I get that most states don't have this particular rule, but mine does, Idaho. Idaho Rule Civil Procedure 4.1, either general or special appearance. So, and it says filing a notice with the court entitled special appearance. So I do it as a notice of special appearance. That's the title of the document. And then in the introduction, it's I am man, creation of God, appearing specially, not generally, objecting to the personal jurisdiction. More specific is I'm of lawful age, I'm of sound mind. So we get those kinds of things out of the way. But this is done as the very first document. Before you ever appear in any kind of a court hearing, this is the first document that needs to be filed. The only other thing that can be done is a continuance, or it admits jurisdiction. So this is the first thing that has to be filed, is you're putting them on notice of who you are. This goes back to we need to learn who we are. So I am man, creation of God, of lawful age, of sound mind, one of the people of the territory of Idaho, appearing specially, objecting to the personal jurisdiction. That's it. I mean, clear and simple. And then under jurat, under oath, not an acknowledgement. So you get it notarized under oath. And then the next step in reading the rule, it says, oh, if you're going to do a notice of special appearance, you have to have a motion to dismiss filed within 14 days of filing the notice. Okay. And under 2, 4, and 5, which if you'll read the federal rules, it's the same thing, Rule 12B. Okay. Idaho is almost exactly verbatim like the federal rules. So filing the notice of special appearance, and then you get into the motion and an affidavit. You have to assert the grounds. Oh, I don't know. Lack of personal jurisdiction, insufficiency of service, insufficiency service of process. Oh, that would be that due process of law. And then there's other grounds if you in your criminal side, and don't be try not to get confused with, oh, well, that's civil. Yeah, it's a civil procedure for that particular thing. Still can be used in the criminal side. So don't let them trick you thinking that no, you can't do that, because technically speaking, these are all the rules of the common law. One body of rules of procedure. So pleadings and practice. So you get your motion done, you got your grounds asserted with a brief statement under that, and these are all actually verified. So to back a notice of special appearance, it's a verified notice of special appearance. It's a verified motion.
What does that mean?
It's verified under oath.
What does that mean?
It means it's under oath, and it's verified by a notary.
Okay.
So for me, I'm an actual Idaho notary public. So I know the difference between an acknowledgement and what some people refer to as under jurat is under oath. So there's two different types of notarizations. And I learned from a paralegal that we want to have these documents verified. It's all under oath.
Okay.
So this goes back to the verbiage in the Fourth Amendment: no warrant shall issue but upon probable cause supported by oath. So when you do when we do these documents and we do them under oath, none of their paperwork is under oath. This becomes the record. So because it's under oath, it can be used anywhere to get a warrant for an arrest.
Okay.
So the next document, typically speaking, within 14 days of filing the motion, now is called a brief. You have to brief them, a memorandum of law, and your points of authority. Now, one thing I've learned here is if you file just the notice of special appearance and the motion and an affidavit, sometimes they'll immediately, send over their cookie cutter objection to the motion to dismiss before you can get your brief in. And that's part of their little trickery they like to do. So anymore, I'm Johnny on the spot, and I file the notice of special appearance, the affidavit, the motion, and the brief all at the same time.
Okay. No slipping in before the door closes, huh?
Yeah, it's just that, it just doesn't leave them any wiggle room. You want to narrow this down, pin them down, and it's time for them to produce some real law, some real documents, and the truth, facts of law.
Mm-hmm.
And you'll find that none of their documents are under oath. You'd be lucky if anything is under penalty of perjury. That's not what the Fourth Amendment requires. It has to be under oath. This whole ideology of, oh, well, under penalty of perjury is part of the corporation's corporate bylaws.
Yeah.
Miranda versus Arizona. There shall be no rulemaking or legislation that would abrogate a right. We have the right to face our accusers, and they have to be under oath. Otherwise, they're not a legitimate accuser.
At any point, do you require of the prosecutor to produce a verified claim?
There is a thing that I have not done yet, but I have heard from somebody else. It's called a bill of particulars.
Uh-huh.
And I have looked into that a little bit in my American jurisprudence books there. And it's a bill of particulars. Okay, let's state with particularity what's the real party and interest here. What standing do they have? What's the nature and the cause of action? Mm-hmm. What are the actual damages? Those kinds of things.
Yeah.
And they have to respond to that. Well, how are they going to respond to that when there is no real party and interest? There is no man or woman who has standing to claim a right to a cause of action.
Uh-huh.
So this is when this was a couple of men out of California that had talked about this. And I was like, man, that sounds pretty good. I just haven't gone down that rabbit hole fully and have attempted that. So
yeah.
But they said that they had done that on a case and they immediately dropped the case.
I'm wondering, is that something that's done when you file this notice affidavit and so on from the get-go to understand the charges, or is that something the court would only entertain after a plea was entered, and that would be considered part of discovery?
Well, technically speaking, that would be the very, 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 very beginning of a case.
Yeah.
So let's say you got pulled over, you got a traffic ticket or charges, whatever. You could do the bill of particulars right from the get-go, and you force. See, now this is the executive branch. A lot of people say court, the court. No, this is the executive branch. The prosecutor sits on the executive branch, not the judicial.
Wow.
Just because you're in a courtroom, the venue, it's just a room, but it gives the appearance that we're going against the judicial branch. Separation of powers here.
Okay.
So what you're really doing is you're going against the executive branch trying to prosecute. But what lawful authority do they have to prosecute without an injured party?
In common law, And they would typically say something to the effect that you're in some other form of law. This is statutory code, and you're a person, and all these things, and that's what you're challenging. Who are you?
Absolutely.
Who
Yeah.
are we dealing with here? Am I the party named on those documents?
So
Uh,
what it is here is what's called the presumptions and assumptions, and there's
all right.
a mathematical equation here, and it's Christopher Hallett, who was my partner at the time. He created this negative nexus. So the first presumption, right, is the police officer writing you the ticket. Well, that's presumed to be true. And then the prosecuting attorney takes that and files the charges. And the judge looks at the record and says, yep, this is the presumptions in the record, and I'm going to assume that this is true unless there's some sort of an objection and rebuttal.
Yep.
So the negative nexus is that sometimes we'll hear people, oh, two wrongs or two negatives don't make a right or make a positive. Well, you don't know math very well, because a -1 times a -1 equals a +1. So we can explain what's going on here mathematically is that the first lie is the name on the tickets and that you've committed some sort of crime that's an arrestable offense without a warrant. And here's your ticket, and you're being charging instrument, not necessarily a claim for damages.
Right.
And then the prosecutor's the second negative, which presents the charges to us, right? And then to the court, right? It's in the court of record. And the judge will assume that that's all true unless there's some sort of an objection and rebuttal to that, to remove the presumptions.
So that's your
Therefore,
notice.
the judge can't assume that that's true.
Okay. All right. So what's been your experience with this? Filing this
My
notice?
personal experience, some of the cases, all I've filed was the notice of special appearance and an affidavit, and they're dismissing. Others, I do a little bit of a battle, like the two previous cases. I actually wanted it to go to trial because it was about trespassing for not wearing a mask. The one case, I just filed the notice of special appearance objecting to personal jurisdiction, and the affidavit that I am not the name, the all capital letters, blah 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 blah, and that preserves my objection, no matter what, because that removes the presumption in the record that I'm a corporation or that I'm something other than man, creation of God.
Yeah.
Once that has been asserted, it can never be assumed. It has to be proven.
Mm-hmm.
And even after trial, even on appeal, jurisdiction can be challenged. Even if jurisdiction's been previously challenged and denied, it still does not admit jurisdiction.
Okay. So it remains on the record as an objection if you put it in if you document it, put it on the record.
Absolutely.
Yeah. Okay. So that maintains an appealable issue then.
Yep.
Yeah. And once
So I've had a CPS case that I helped a woman with, and used the same stuff on a criminal side case, and was in Minnesota. And Minnesota actually has a document template for a motion to dismiss, and it cites their criminal, civil, and their general rules. So it cites all three different rules in this motion to dismiss. So it can be used in any position, any jurisdiction, if you want to go there. Anyways, so we took the document templates I had used in a criminal case and sent that to her, and she rewrote them up for the CPS case. And somebody decided they didn't think that was all correct or whatever, and modified it and changed it, and they filed that paperwork, that the notice of special appearance, the motion, and the brief. Mainly messed up the motion, and the judge denied it, or actually ignored it. They totally ignored it. The court prosecutor, whatever, they all ignored it.
Yeah.
And then when she showed me a copy of it, boom. I was like, no, I told you, do not alter this. This is the proper format, blah, 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 blah. So she redid them. Actually, she was helping her sister and redid the documents, filed those documents. 2 days later, the judge called the mother and said, go pick up your kids. I've vacated your entire case.
The kids had been previously
kidnapped. Yep.
Yeah.
And part of what it boils down to is that, they have no lawful authority to make an arrest without a warrant. They have no personal jurisdiction. They don't have an accuser. They don't have witnesses. They're not following due process of law.
Yeah.
Per their own code and the Social Security Act, Title 4D there, everything is supposed to be done as an agreement and with the intent of keeping the family unit together.
That makes sense.
Why are they taking the kids?
Yeah.
If there's some sort of a crime being committed against one of the children, if you use that, and that's the other thing is the words that we use, but I'm just going to stick with this for just a second, is that where is the evidence to support the claim that there was child abuse or sexual abuse? And then if there is those kinds of things, don't we usually remove the criminal? We don't remove the children, right? The words, proper diction here.
Oh.
And this goes to the word jurisdiction.
Uh-huh. The words of the law.
So juris is not diction, is of that law. It's a body of law. So for example, parent and child comes from parens patriae, Latin for the state is the parent. So when you go into their courts, their jurisdiction by using the words parent and child, that's their code, the Roman civil law, which is parens patriae. Now, when we want to come in under the laws of nature, God's law, right?
Yeah.
And that is father, mother, son, or daughter.
Okay.
And then it's chattel. That's my chattel, my property.
Uh-huh.
So when you use those words, that's a different jurisdiction. So that goes right into why there's a lack of personal jurisdiction, because there is no jurisdiction over father, mother, son, and daughter, only over parent and child.
Wow.
So it's all about the words that we use, the diction.
Uh-huh.
And so that basically pulls the carpet right out from underneath them when you say, no, I am father. This would be in your notice of special appearance, say for the family case. Okay, I am father, right?
Yeah.
Over my son.
Who is my property.
I'm of lawful age. I'm of sound mind. Those key phrases need to be in there. But that's how you're appearing. I'm appearing as father, and that's my son. That's my chattel. That's my property. And I'm demanding my property be returned to me that's been stolen. Judge.
Uh-huh.
Remember, because justice is to be without sale, denial, or delay. Supposed to be ensuring justice here. You're the umpire. You're the referee calling balls and strikes here. And I'm accusing them of stealing my property.
Right.
And I'm here to demand my property be returned to me now, immediately.
Mm-hmm.
So now this puts them in a pickle, because now you've just stated that somebody stole your property. How are they going to sit there and say that they didn't when they're in possession of stolen property?
That's right.
They can't turn around and say, well, no, we have the child. No, you have my property.
Yeah.
And they can't tell us that we have to use those words, because we have the right of conscience. We get to think for ourselves, and we speak how we speak. Whether they like that or not is irrelevant.
That's right.
Because that's jurisdiction.
Yeah. What a tangled web we weave, huh? So this woman messed up your original documentation, went back and got nowhere, went back in, redid it, and upon submission of the facts and the obvious, with the proper jurisdiction, the judge recognized that and immediately responded favorably, huh? Wow.
Yeah, 2 days, made a phone call, said, go pick up your kids. I've vacated your entire case.
Oh,
You ever
wow.
heard of that one?
No, I haven't. That's powerful. People need to understand that. And it's so simple.
Yes.
It's so simple. And yet, how many
You would think.
kids have been kidnapped and have been sequestered?
Yep.
Oh, all right. Well, this needs to get out for sure. Okay. So, as courts typically do, they often will ignore whatever you put in front of them and routinely deny due process. So let's talk
Absolutely.
about that.
So, a violation of due process or deprivation of the right of due process of law is one of those grounds that can be asserted in the motion to dismiss. That's part of that 2, 4, and 5. One is personal jurisdiction, one is insufficiency of service, and the other is insufficiency of service of process, due process of law.
Okay.
So that is one of your grounds that can be asserted in the motion to dismiss. Now, if the judge denies your motion to dismiss, you could do a motion to reconsider, but you could also go directly to the common law with a writ of prohibition, which goes directly to the Supreme Court. So that is, in essence, just for lack of jurisdiction, or when a magistrate or so-called judge acts without lawful authority. That's what the writ of prohibition is for. That's it. Without jurisdiction. And when you go through this, when we go through this process and we file the proper paperwork, you're giving them notice, because that's the first fundamental principle of due process of law.
Right.
Give notice and opportunity to respond.
Mm-hmm.
So that's why it's called a notice of special appearance. You're giving them, we get to tell them how we are appearing. They don't get to dictate to us. They don't get to dictate the record. We create the record. And we give them notice, because that's how we're supposed to remain in honor.
Right.
They've made an error, a mistake. Right? No man is perfect. So you give them notice and afford them the opportunity to do the right thing. But you're creating the record that you gave them notice. So it doesn't matter what they do after the notice. They've been told. They've been put on notice, and you have it verified under oath in a certificate of service, or you can do registered mail, however you want to do it. That's, you can prove, right? We prove that we have given them notice. And then after, when the magistrate or judge or whatever denies your motion to dismiss for lack of jurisdiction, that is a writ of prohibition. And this is basically goes to the Supreme Court and says, hey, look, I challenged all this stuff. Here's a copy of the record. And they have to review the record to see if the other side proved that they have jurisdiction. But they're also looking to see if you gave proper notice.
Yeah.
If we have given proper notice, if we have followed due process of law. See, this is the thing. So many people sit there and say, well, they're violating my right to due process of law. Why are we not following due process of law? We're just as guilty by not giving them notice, by not doing the proper paperwork. We're violating their right to due process of law as well. Works both ways. The law applies equally to all.
Well, the thing is, the law establishes in numerous cases that I've seen that once jurisdiction is challenged, then facts must be put on the record to establish it, if they have any. But of course, they ignore that every single time. Yeah.
Yep.
So people need to understand,
Absolutely.
in order for the court to stay in honor, if you challenge jurisdiction, then the prosecutor needs to put facts upon the record to establish that, yes, we do have jurisdiction, and here's why. Here's the facts. But they never do. They never do. And so that needs to be always objected to.
Well, most of the time, that's how the case gets dismissed.
Yeah.
So in that instance where they do not respond with an objection to the motion to dismiss, the maxim of law is he who leaves the battlefield first loses.
Yeah.
Okay. This is a little battle going on here. You give notice, you afford them the opportunity to respond. They don't respond with an objection. So the presumption in the record is there is no jurisdiction. And the judge has to assume that that's true because there's no response with an objection and a rebuttal and proving how they have jurisdiction.
All right.
So the judge has to assume that the objection initially made is the truth because that just removed all the presumptions.
Well, and in
Those are
law,
facts on the record under oath.
yeah, and you can look it
right?
up for corporate.
So then that's a default.
Yeah, yeah.
Default judgment.
Failure to object is fatal.
After 21 days, right? After 21 days, after proper service, they have 21 days to respond with an objection and prove jurisdiction in writing. Not see, that's the other thing people need to learn. This has to be done in writing, all of it. You can't just walk in there and go, I'm objecting to jurisdiction and they got to prove it. That's not how that's done.
No.
So many people think that they can do that and get away with that, and it doesn't work. Now, I know on certain instances, it can be done and it might work. It may have worked for certain people, but part of what I teach people is the long game. And doing this for more than just ourselves, for one man. Sure, you can do this and get it dismissed for yourself. The key is to take this down, take it further, the long game, and take it down for everybody else.
Yeah.
That's the key.
Start sending
being a warrior for everybody else.
Yeah. Yeah. Going back to, you mentioned insufficiency of service. Just to clarify that, are you saying the service is insufficient because it's a misnomer? It's naming the wrong person?
No, that particular part is about proper service. Who's supposed to serve a summons and a complaint? Well, who has that duty to perform?
Well, that could be
the sheriff.
Yeah.
Absolutely. That is a power properly belonging to the sheriff, which the sheriff is supposed to be the bailiff standing there in the courtroom. Whether we're there or not, somebody's doing some of this stuff to us. That's supposed to go to the executive branch, the sheriff, and the sheriff is the process server. Now, on civil things, I guess you can hire a separate process server. But when it comes to criminal stuff, that's supposed to be done by the sheriff.
And that's found in the criminal rules of procedure?
Well, that's more or less part of the common law and the fundamental law, but that's the power that belongs to the sheriff.
Yeah, okay.
So it doesn't even really have anything to do with rules of procedure. That's law, real law, common law.
Mm-hmm. Okay. So back to the writ of prohibition, is that drawn up in a way that you're laying out the case and asking the Supreme Court to issue a writ, or are you writing the writ? Okay, the first one. All right.
It's all kind of the one thing is the writ of prohibition. Then you have to attach the copy of the record, and then they have to review the record and either grant or deny the writ. And it's actually fairly simple because you're not making any arguments or anything like that in this writ because you've already made all of your arguments over here.
Yeah, you're showing the facts.
This is just hey, I challenged jurisdiction and I'm claiming that jurisdiction was never proven. And the judge acted arbitrarily, usurpation of power, subversion of law, and failed to ensure justice here. And I'm demanding a review and to grant the writ of prohibition to prohibit them from carrying on any further proceedings and to dismiss the case. And in fact, if they grant the writ of prohibition, the case is essentially automatically dismissed.
Would that work equally with a U.S. District Federal Court?
Absolutely.
Taking it to the U.S. Supreme Court?
Absolutely. A writ of prohibition is a common law writ. Mm-hmm. That is one of those right to petition the government for the redress of grievances. When we're talking about going to the judicial, common law writs, writs of error, writs of prohibition, writs of mandamus, writs of quo warranto, writ of habeas corpus, those are all common law writs.
Uh-huh.
It's from the common law,
Yeah.
not statutory law.
Okay.
So those impose duties, and in the code or statutes nowadays, they say, oh, well, it can be done by the district court. No, the common law dictates that goes to the Supreme Court, the highest court in the land. The inferior courts do not have that authority.
In other words, no more dicking around.
That's right. They want us to go, oh, well, just if you're in the magistrate division, you could go to the district court. And then if you don't like that, then you could go to the appellate court. Then you can go from the appellate court to the Supreme. No. We go straight to the highest court of the land, which is the Supreme Court of the state. And they decide. That's it. You skip all the BS and go straight to the top.
Well, yeah. I mean, people get put into the grinder, and to go through all those steps is too much for most people. So
it is trying to look at all of this stuff and take it in as a bigger picture, and not having any of the pieces of the puzzle. It's hard to grasp the bigger picture when you don't know the pieces of the puzzle.
Yeah. So what have you seen as far as people using a writ of prohibition?
Well, we had one of my students had some success with that here recently. Denied the motion to dismiss, right? And did the writ of prohibition. And the day before they had to give their opinion or ruling on the writ, whether either to grant or deny, the prosecutor's office called and said, hey, the day before trial, we've dismissed the case.
Really?
Wait a minute. You didn't want to dismiss the case on the grounds that I asserted by motion, and because now I go over here for a writ of prohibition, and it forces the showdown, because in the writ of prohibition, you have to put in there the date of the trial. So that sets the timeline of when the Supreme Court has to respond by to prevent the injustice.
So you send a copy
of some of these writs.
You send a copy of
these
the
writs.
Prosecutor?
I believe the Supreme Court sends that down, but technically speaking, under a writ of prohibition for where jurisdiction has already been challenged, that the other party doesn't. They don't need to be served. They don't need to afford the opportunity to respond. Now, if you're talking about the judge who's acting outside of his jurisdiction within any time, boom, that's an instant, yes, writ of prohibition, and you have to give notice and an order to show cause, and they have to appear, they have to respond. This forces the showdown with the judge acting without any kind of authority, lawful authority. So like an usurpation of power, exceeding the laws of its creation. Not for when you're challenging jurisdiction and the judge denies. That's the only two ways a writ of prohibition works. One does not require notice because you've already given them notice and they denied it. Right. So the record reflects that the judge culpable by denying justice. Writ of prohibition for lack of jurisdiction. The other one is during any time, during any case, when the judge exceeds their authority. That's a writ of prohibition.
Okay. Well, I'm sure there's a lot of details that we could get into, but those often require, specific instances, and have to take that on a case-by-case basis. But this has been thoroughly enlightening, and hopefully the people watching this can kind of see their way clear of possibly getting some remedy in these corrupt courts. So there is a path.
Absolutely. There is a path. There is a process that is due.
Yeah, we'll leave it at that. Do you have any final comments that you'd like to add?
Just remember, keep this in mind. It's a psychological warfare here. They want us to get all riled up and pissed off. The first court you go into is a de facto kangaroo court. Create your record and don't worry about what they do. Follow due process of law and hold them responsible later down the road.
Yeah,
Don't let them get you all riled up, because that's what they're intended to do, and they get off on that stuff. So remain calm. Fine, you want to play that game with me? You're going to do what you want and catch you if I can. I'll be your hucklebearer. I'm just going to smile, remain in honor. You
yeah.
won't be on the bench for long. Not when I get done with you.
I understand how they get off on that, because I used to get off on it myself, showing up in courtrooms just to throw a wrench into the wheel and watch the prosecutor's face get red and blow steam out of his ears. So for me, that was high level entertainment.
It is. So think of it the other way around. You know, these people are evil. They thrive on tormenting us.
Yeah, yeah, they do,
Yeah.
and they profit on
You're
it.
evil.
They profit on our misery.
Yes, absolutely.
Yeah. So, well, Kirk, thank you very much. We'll leave it at that for now. And it's been intensely valuable. And hopefully, this will be a ray of light in the dark for folks watching. And we'll just take it from there. That's what you're doing. That's why you're doing what you're doing. That's why NATF is doing what we're doing, and just trying to bring information together so that we can use it and put the rubber to the road, make it work for people. So, Kirk, thank you very much. Appreciate you.
Thank you, Mark.
All right. So, folks, this is only an icebreaker video, the first in a series that we'll be putting together for your benefit. And from this point forward, on this particular topic, we're going to be drilling down on the paperwork. What does the paperwork look like? What should be the substance, the content, the procedure, how to deal with it, how to get it into the court, all the technical aspects that you're going to need to properly execute this strategy for your own benefit. Okay, so stay tuned to announcements. Be sure you're on our mailing list. We ask that you support NATF. We're doing everything we possibly can to help restore the rule of law and to help you defend your rights. All right, so see you in the next video. Watch the series as it comes up. Take care, and may God bless. Bye for now.